Well, I didn't ask Billy for a bio. I think most of you may know him, but one of the things I've found, one of the great pleasures of living in not just a small town, but our small town, not only getting to rub shoulders with each of you that bring so much value to the lives of my family, to my children, to me personally, it's knowing, being able to know on a personal level the leaders of our community. I've known, at least to some degree, Billy since we were boys playing baseball. He played in Gladewater, played in Gilmer, but one of the great loves of my life is baseball. And then somebody I've admired all my life. On a personal level, him as our great district attorney. Unfortunately, as things go, sometimes that's somebody that we need in our life, and had a very personal issue in our family, and it was very nice that at 7 o'clock one morning I get a call from our district attorney letting me know on a personal level that things were in very capable hands. And so with all that said, with no further ado, I'd like to introduce you to our district attorney, Billy Byrd.
Well, good afternoon. Thank you for having me. I really appreciate the introduction from Mr. Dodd. When he called last week and asked me about being here, of course, it's always a pleasure, and I always want to take that opportunity because I enjoy getting out. I don't get to do that near as much as I would like, but I enjoy getting to see people in our community. I meant to ask him last week, now everyone's going to be standing for the pledge, right? Otherwise, I'm not coming. But I was happy to see that. It's a pleasure to be with you here today. I'm going to talk about, I want to leave some time for questions that may not be related to this subject matter that you may have on your mind or a question you want to ask. So I want to leave time to answer those. But I want to share with you a little bit of changes in our law, something that you've probably heard about and may not understand exactly what that is. Is somebody ever heard in the media that something called the Michael Morton or the Michael Morton Act? Anyone ever heard that in the media? Okay. That's okay. That's not something that would necessarily affect your day-to-day lives, but it certainly affects mine. And I want to explain a little bit about who he was, how he ended up going to the penitentiary for something he didn't do. He spent 25 years in prison, only to be exonerated later in life and released and pardoned from a sentence on a crime he didn't commit. I always tell prosecutors when I get the opportunity to train them, and I've trained many over the years, I always come with three things. We do it the right way, against the right person, and we seek the right result. The right person, the right way, the right result. Unfortunately, because of one person named Ken Anderson, he was an elected district attorney like I am in Williamson County. And many years ago in the late 80s, he was the elected DA, and there was a family that lived in town. Michael Morton was the father. His wife's name was Christine, and they had a 3-year-old son named Eric. And on one morning in 1987, ultimately, Michael got up, he got dressed for work, he left at 5 a.m. Later, a neighbor heard screams coming from his house, went to investigate, went in and found Christine's body on the bed. She was covered with a suitcase and a wicker black basket. She was bludgeoned to death, blood everywhere. 3-year-old son was still in the house, Eric. And there were a variety of things in that room that the police came out and they began an investigation. And I know we have a whole slideshow on this, and I'm kind of skipping through because I want to leave some time to how this applies and why this is important. Why am I bringing this up to you today? So that you'll understand the process maybe a little bit better when we leave here today. So Michael Morton was a suspect. Police investigated. They ultimately arrested him. He was indicted. He was taken to trial. He was prosecuted and he was sentenced to life in prison for the murder of his wife. The many problems existed in that case. Number one was there's this thing that we are constitutionally bound by called Brady evidence. Brady was a United States Supreme Court case many years ago. What that requires is, if I as the prosecutor know that evidence exists that's favorable to the defendant, that may exonerate them, may prove their innocence, may prove that someone else committed a crime and not the person on charge, I have a legal obligation, constitutional duty under my oath to provide that evidence to the defense. I have the duty to do that whether they ask for it or not. I have a responsibility as a prosecutor to make sure that the integrity of the system is kept intact and that justice is accomplished in any particular case. Back in 1987, what Mr. Anderson had at his disposal there was a bandana left in the bedroom. It was bloody, it was evidence, and it was collected. The other thing that's important, Eric, the 3-year-old son, gave a statement. And he said, in his statement, he said, "A monster with red hands kept hitting Mommy." It's a 3-year-old, that's age-appropriate language, but this is who he's describing. You noted he didn't say, "Daddy kept hitting Mommy." A monster with red hands kept hitting Mommy. Ken Anderson didn't tell the defense attorneys about it. The defense attorneys filed a motion for exculpatory information, meaning evidence favorable to their client, Michael Morton. Ken Anderson didn't disclose it. Ken Anderson didn't tell the defense that there was a bloody bandana left and recovered at the scene. He didn't tell the defense about it. Now, somewhat to his defense up front, the police didn't disclose it to the prosecutor initially. But prior to going to trial, Ken Anderson knew about the bandana and he knew about the statement. So once he knew, he should have disclosed it, but he didn't do it. Michael Morton's convicted, he's sentenced to prison. DNA in 1987 had not evolved. That's something we've grown up with, not in 1987. Michael Morton is sitting in prison and he files what we call a post-habeas writ for DNA retesting because DNA had acquired. So you know, on any case that you've read about in the Gilmer Mirror where somebody's been convicted of murder and we have biological evidence, bloody evidence, semen, physical evidence left, it's kept and maintained and preserved. Because at some future time, any one of them may challenge the testing that was done in 2017 because standards evolve in 2025 or 2030 that may lead to a different result. So this evidence was kept and it was maintained. And Michael Morton from a prison cell filed a motion back in Williamson County asking for an order to have a bandana that he later learned about, he didn't know at trial, tested. Well, it was tested. Guess what? It wasn't Michael Morton's blood. His DNA was not on that bloody bandana. It was also disclosed at that point that the 3-year-old had made this statement about the monster. That wasn't disclosed at trial. So as a result of this, and I believe it's 2010, the judge grants the motion, and this man, Mark Allen Norwood, who had been put in prison before, if you go to prison, they're going to take a cheek swab from you. And from that cheek swab, they're going to make you a DNA profile. Everyone in this room has a unique DNA profile that's different than everybody else. We all look different, our DNA is different, with the exclusion of identical twins. But everyone in this room is going to have a different DNA profile. Mark Norwood had been to prison. His DNA was in a database, and when they took this bandana and tested it, they came up with a profile scientifically that proved that it was Mark Allen Norwood. When it came out, Ken Anderson at this point had gone from the elected district attorney to the elected district judge. He's on the bench, he's presiding over cases. This evidence comes out, a judge orders his immediate release from prison. He worked with the Innocence Project, which is an organization you may have heard about in the media. Michael Morton's released. ultimately exonerated, and then Norwood was prosecuted for the murder of Christine Morton, Michael's wife, and was convicted and sentenced to prison. He spent 25 years there in the penitentiary. The defense, of course, asked for this information up front, and it was not provided. So, as what generally happens when it becomes a hot topic issue, one person, one prosecutor who made a wrong decision and a bad decision and didn't do it ethically right, that causes the legislature to come together and think, we need new laws. Now, bear in mind, what I told you up front was I have a constitutional responsibility to disclose evidence favorable to the defense. I don't have to have them ask me for them. I've got a job and obligation to ensure integrity of the system, to tell them about it and give it to them to make sure, again, right person, right way, right result. Ultimately, what happens to Ken Anderson? Ken Anderson is tried for his sentence. It was a public trial before a judge. The judge assessed that he should be disbarred, lost his law license. He was given a 10-day jail sentence, I think 500 hours of community service, and some court costs. To be quite honest, that was not near enough. When you had knowledge and information that this man may not be the person who did the crime, stiffer and more severe penalties should have been assessed. No doubt about it, in my opinion. That was the result of the prosecution of Ken Anderson. He's no longer a lawyer and is, of course, removed from the bench as presiding district judge. So now the legislature meets every 2 years, as we know, in Texas, and so they took a liking to this story. It was a hot topic story. It was sensational, and I understand that. Man spent 25 years in prison when he shouldn't have. And that's bad. That's wrong. It should never happen. So the legislature came up and they started creating new laws. And they amended under discovery, so you know how it works. What discovery means is evidence. What everybody has about a case. The law says I, as the prosecutor, I have to give everything to a defense attorney. I have to provide all of my witnesses. I have to provide every shred of evidence that I know exists. The defense has to provide me nothing. They do not have to provide me witnesses. They do not have to provide me evidence or physical evidence or photographs or videos they may have. Sometimes they come to court with evidence that I was unaware of or try to get it into evidence. So they don't have to provide me anything. I have to provide everything to them. The legislature said, okay, we're going to take Michael Morton and we're going to create a new act and we're going to make it a law, not just a constitutional responsibility, not what the United States Supreme Court's written as law as it applies to lawyers. We're going to make it a formal statute in Texas under 3914, which is our discovery. That means the rules that govern what we do and don't do about a case. So they created a new law, 3914. And it goes in, hey, go back to the last one. And you'll notice the legislature, here's what they said. In an apparent attempt to avoid another miscarriage of justice, the Texas legislature enacted this bill. Thousands and thousands and thousands of cases have been prosecuted since 1987. One case, one bad judgment, one bad mistake, and this is what you're going to see as the result of that law. What you're going to learn is it doesn't apply to the police. You're going to learn it doesn't apply to defense lawyers. You're going to learn how the prosecutor, the elected DA, is in the bullseye every case, every day, and what can happen to us, to me. And so they passed new law. And it says you got to play fair and give everything to them. These are things we do on every case. I always have made a practice and a principle of that from day one. Back in 2001 when I started as a prosecutor, I've always done that. So I have no reservations. I don't lose sleep at night wondering because I'm going to make sure, no matter how many hours it takes, that we did everything we could possibly do on any given case. So they passed the law that says you've got to return it and give it over to the defense. Here's what happens if you don't. Let's go to prosecutorial accountability. Go back one.
is what the new law says. It says that we must make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense in connection with sentencing, disclose to the defense all and to the tribunal, that's the court, all unprivileged mitigating information known to the prosecutor. You see this word where it says known to the prosecutor? This is where it gets really sticky. If we have any criminal case and it's investigated and the case is turned into my office, I have a checklist. And these law officers have to check off what we have and don't have. Do we have a 911 recording? Do we have dash cam video? Do we have body cam? Who all was at the scene? Did their body cam pick up something another one didn't? Did they talk to a witness somebody else may not have on the original officer? I have to have all of that because any person at a scene, as we know we have some law enforcement here, scenes get chaotic. And there's people running in and out, doing all sorts of things, and somebody may have seen something, body cam video, and it's not written in a report. I have to have every single video, every single shred of tape, anything that happens, I've got to know about it. Now, think about this for a second. If I'm not at the scene, and I can't be at 10 places all at one time with all these people running around, who do I rely on to provide that information to? The police, the law enforcement agency. What if they don't supply it to me? Anyone want to guess what happens then? What happens if law enforcement doesn't turn it into me? Anyone? Well, I'm going to tell you, nothing happens to law enforcement.
But you're still responsible.
That's right. I'm the one responsible because the law now says, even if I don't know about it, I do know about it because as the administrator of justice, as the elected DA, I've got constructive possession of the evidence locker at an agency. I've got the ability to go out and find every witness that was there who never wrote a report. And by the way, sometimes they don't. And I've got to go find everybody that was there to find out if they know something that might lend to the innocence of somebody being prosecuted. So I tell people all this all the time. If I was to ask you to give me all the money in your wallet right now, and you handed me over $10 that you didn't spend on the raffle, we're going to look at it. No, that was fun. Nothing wrong with that. Nothing wrong with that. And you give me $10. And over here, I've got a duty to disclose it. You've asked for all the money, and I give you the $10. And you say, are you sure it's all? That's all the money. That's all the money. I'm sure. I'm going to sign off on a piece of paper and tell you that's all the money you have. And then later we find out when we walk out, when he gets in his car, he's got a $100 bill in his shoe and he pulls it out. Well, guess what? I'm relying on the honesty and the integrity of that law enforcement officer to provide me it all, and then I've got a duty to tell you about it. Now, if I learn later he wasn't truthful, the law says, me as the prosecutor, I'm the one that's going to be punished for that because I should have shook him upside down, took his shoes off, and jingled his pockets upside down to find him. That's what the new law standard is in the state of Texas. That's the level of scrutiny that we are under as prosecutors to make sure things are done right. The prosecution team, that's everybody. The receptionist at my office, the investigator in my office, the investigator from the sheriff's office, any agency, to be honest, the funeral home who picks up somebody at a scene, to the EMS driver who comes out and checks vitals. That's all part of the prosecution team on any given crime scene. It takes a lot of work and a lot of integrity from everyone involved on any scene, on any given crime scene, to do it right, the right person, the right way, to get the right result. Otherwise, the law says bad things happen. Billy, you can be disbarred. Billy, you can lose your ability to practice law that you've worked so hard for all these years, and you could just be sent home and looking for another job. You could go to jail. You could be prosecuted for the wrongful conviction of somebody who didn't do a crime. It's your job, Billy, to make sure everybody in a county that sends you a case to prosecute, they did it right, they gave you everything, they told you they had it, and they provided it all to you. And if I learn after a trial somebody's in prison, and I learn that extra evidence exists, I still have a duty to continue looking and then say, hey, hold everything. I know the person's in prison. I know they've been sentenced to life, but I've got a duty to disclose to the lawyer, to the defendant, that new evidence came up. It never ends. It never goes away. There's never a time where a case is over. It always keeps going. You read about results in a paper and you think, well, that looks like that's over. That's not over. It's the beginning. Many of the cases, these issues never come up. 95% that they won't. But there's 5%, and we have plenty of those. We have plenty of murders. We've had capital murders. We've had manslaughter. We've had home invasions, sexual assaults. You name it, we have it here in Upshur County, just like they have in Dallas. Maybe on a different volume, but we have the same crime. The same criminal element exists, even in our county. That duty keeps going. So when you hear the media talk about the Michael Morton Act, I want you to know who he was. He was a man who went to jail in prison when he shouldn't have. Spent 25 years there when he shouldn't have. Based on a prosecutor, and I hate that I'm having to talk about it. But an elected prosecutor like I am failed in their duty and their responsibility. This is something I want you to see. Let's go to Article 201. I share this with juries all the time. And it said, Article 201, this is my oath. It says, my oath is not to convict, but to see justice is done. But this is the part you never hear about that is also part of that same oath. I shall not suppress evidence or secrete, hide witnesses, capable of establishing the innocence of the accused. That duty never ends. It's before they're arrested, after they're arrested, during the trial, after the trial. I've been in situations where I had someone pleading guilty, not here, I was in Gregg County, pleading guilty with a lawyer. I felt something in my gut told me something was wrong. And I stood up and said, Judge, I move to dismiss this charge. I didn't know what it was. It wasn't a murder. It was a minor offense, but something told me something was wrong. Come to find out, she didn't do it. There was a person that looked very close and similar to that individual that actually did do it, and she was standing before a judge pleading guilty and already signed the paperwork. I tell you this because if I plot, these things don't ever go away from me. These things are all the time on my mind, and sometimes in the middle of the night when I wake up, because I want to make sure that we do it, because ultimately, I've got a responsibility for you, as your trustee, as the elected DA of this county, to ensure that all this is being handled correctly, professionally. It takes a lot of work from good officers, well-trained prosecutors' office, and people in our office. And it requires all of us to work together in order to get the right result, and that's very important. So I hope that that sheds a little light on who Michael Morton was and what these new responsibilities are. And I tell everybody that it's the prosecutor who's in the bullseye. Now, at the same time the legislature passed this, just so you know, they did some amendments to offenses where capital murder would apply. And there's a long list of people on that list. If you kill one of them, you could be subject to the death penalty, lethal injection. There's one category of professionals that aren't on that list. Anyone want to guess? The district attorney. So if we get killed, you're looking at 99 years with the possibility of parole. If you kill a police officer, fireman, 2 or more people in the same episode, aggravated robbery, you kill someone, home invasion, rape, kill, you're looking at the juice or lethal injection, but a prosecutor, you're looking at 99 and the possibility of parole. So at the same time, these laws were passed, putting us in the bullseye. These things were not addressed by the legislature, and that's okay. So you in the back of your mind, you're wondering, why in the world do you want to do this? And I understand, that's a fair question. And I've asked myself that too over the years, but it's a calling that I love to do, and I feel called to do it. And I've enjoyed having the opportunity to do it here in a county where I was born and raised. And I appreciate the opportunity for these many years to be able to do it. And I'm hopeful that I'll keep getting to that opportunity. So, y'all have any questions?
I do.
Yes, sir.
The obvious question, have you seen things improve since the passing of this law to where things are handled in a more
Not Upshur County, no, sir. The things that all this law address, these are things that I've just made it a policy and a practice over the years to do these things anyway.
I mean statewide.
Statewide? No, I think all the prosecutors would have, and you know, here we're talking about Ken Anderson. This was
One person.
one person. This is not the standard.
Right.
I can assure you, people take this job very seriously. This is not the standard. I cannot tell you that there has been improvement statewide. I think most prosecutors understand the integrity that must be used when they administer justice in their county. So I can't testify or say I've seen any changes. Yes, sir.
Does this apply to plea deals or just,
Very good question. I like, the question was, does this apply to plea deals? It does.
okay.
Anytime we go to court and we have a plea, I require what I call a prosecution report. It's a checklist of items that we have or don't have, and it's addressed. I give it to the defense lawyer. The defense lawyer signs it, acknowledging I have disclosed all of this, and then it's entered into evidence, even at a plea, so that the court knows, Judge, this is all the evidence I'm aware of. I've gone to the depths and extremes to find it. This is what we have. I've given all of this on this paper to them, and I'm going to put it into the record to prove what I did. Yes, sir.
The responsibilities that the prosecutor's under now, or even before, is really couched in the idea that a person has to be proven guilty rather than proving that they're innocent. Is that correct? Is that the
Yeah, the
kind of
burden is
general
still-
viewpoint?
Yes, sir. The burden is still on proving someone's guilt beyond a reasonable doubt. That standard still applies. The ongoing new change or the standard would be, I say new, it's not new. And that's what's so hard about this subject matter for me to talk about, knowing the way that we've done business over the years. But the legislature felt led to make it a law and put penalties, criminal penalties, and what can happen to a prosecutor if they do something like Ken Anderson did. So I don't see that it's new, nothing's changed. I can't say that there's been any improvement, but the legislature had an outcry from the public, and I agree. No innocent person should be sentenced and lose their freedom. I believe in that. Dig down as far as I can find myself, and in the depths of my soul, I believe that. But they felt the need to put this into a law, and so that's why they did that. Yes, sir.
Are you still liable if you have you have this duty to disclose evidence, and the evidence is there, but you don't know the evidence is there because this policeman didn't file his report or whatever. And then at some point in time, whenever that point in time may be, you become aware of this evidence, and then you relate that to the defense attorneys, well then that excludes you from what you're talking about. Is that correct?
Yes, once that it's just, I learned about it. I didn't
Even
know
though it's
it.
later down the line.
Absolutely, years down the line, I learned about it. I've got a duty to disclose it. What I'm gonna do, I'm not gonna pick up the phone and not have a paper trail. I'm gonna file a motion with the court. Judge, new evidence exists. I'm making the world aware of it, and I'm gonna put it in the record so that everyone knows. The duty would be, where I would be in trouble if years down the road, I learn about it, and I do nothing. What happened in that case was, evidence was put in a drawer, and the drawer was shut. Well, that's not gonna happen. But if it does, if something like that happened, that prosecutor, whoever it is subject to penalty, losing their license and going to jail. Yes, sir.
If you're retired, you just come back on?
That's a good question. That's a good question. Yes, sir. The answer would be yes. It still would. It wouldn't matter if you're in office or not. If you prosecuted and were in charge and administered and then you later learn, if you're out of office, it's going to probably be harder for you to learn, but if you did learn out of office that you were part of a prosecution of an individual, that evidence existed that should have been disclosed, and you don't do anything about it, under the new laws, you still could be held accountable. It never goes away.
Would you be under civil liability?
Civil liability too. Yeah, you'd have both criminal, incarceration, civil, where you'd be subject to paying money. Yes, sir.
I don't want to stay too long on this, but I want to mention that term plea bargain again. Do you know about or think that there's any big questions. In other words, I've never been in a criminal case or never been in law stuff, so I don't know. But I just know that sounds strange to me, plea bargain, because it just sounds complicated. So would you have a comment on whether plea bargain is kind of a controversial thing, and are there some people that are thinking about trying to do away with plea bargains, or what's your comment on that?
Well, my comment are 95% of your criminal cases will result in a plea bargaining agreement. Two parties come to a compromise in the middle where both give up something in order to render something that reflects what justice should be in that case.
Yeah.
That's gonna be 95%. In every case that we had, 800 felonies, another 600 to 700 misdemeanors, 1,500 cases a year, we couldn't try all those. There's no way. Yes, sir.
Has other states had this problem?
Sure, yes, sir. No, this is not unique to, well, let me back up. Have they passed laws addressing things like that? Yes. As to any specific with a prosecutor, I'm unaware, but Michael Morton was nationwide. I mean, this garnered not Texas attention, national attention. So some other states also took these things up in their legislative bodies and passed laws similar to reflect what we have. And they just wanted to, and their position was, we want to prevent something like this ever happening. Yes, sir. Yes,
How
ma'am.
do you determine, like, when you have so many cases and stuff, how do you determine who goes, which one goes forward and which one, you know?
That'd be for another session. That's a whole long topic. Well, you have to receive that case, you have to read it, review it. Is there evidence here to support a crime was committed? Number one. Was a crime committed? Okay. Then what evidence do I have that I can legally use in order to return to convict this individual? Was the evidence received lawfully? Was the search done in light of constitutional standards? There's a lot of reading. A lot of reading goes in. And so we have to analyze that case. Does the facts, do we have facts and evidence a crime was committed? What's the law say? And what's the charge? And what's the likelihood that this case would succeed in a court of law in front of 12 people? I look at it as, I'm not going to charge somebody with the idea we'll strong on them. That's a miscarriage of justice. We analyze cases, will this fit in a courtroom before 12 people in a felony trial? And will those 12 people look at this evidence favorably to convict this individual of the offense? That's standards high. You want to make sure you get that standard. And we file a lot of cases because we have good officers. We've got good people in this county. You should rest assured of that. Mistakes happen. I make mistakes too. I'll be honest. But we've got good professional folks in this county that are working very hard.
Isn't that ultimately though in the grand jury's hands?
Sure, grand jury, even a crime's committed, even if it's on a person's own video committing a crime. A grand jury could look at it and say, you know what? I don't think this person should stand trial. That's the power of a grand jury. There's all these checks and balances within our criminal justice system. So
Or you could say that I don't think I can prosecute this, yet here's the evidence, and the grand jury could say, well, you're going to try it.
Yeah, that happens too.
I know.
Yes, sir. That happens too. Good question. Yes, sir.
Yes, I'm curious about the responsibilities after you retire. Let's say, in this example of the bandana, that Anderson had retired, and let's say the bandana had not been in evidence, but he heard from somebody that this bandana existed in somebody else's possession. This is after the retirement. Would he be responsible for investigating that or seeing it's investigated?
Or calling the local authority in office at that time to disclose
He's heard it.
To be honest, if I'm fortunate enough to live long enough to retire, my retirement will never, there will not be just retirement without thinking of these things. These things will always be there.
Okay.
Thank y'all very much. I appreciate it.